All rise.
Please be seated. I am calling 19 CF 20. It's State versus Jake Patterson. Mr. Patterson appears in person and with attorneys Richard Jones and Charles Glenn. The State appears by District Attorney Brian Wright and Assistant District Attorney John O'Boyle and Assistant Attorney General Annie J. This is the time scheduled for preliminary examination. Mr. Glenn, you inform me that your client wishes to waive preliminary examination?
Your Honor, Mr. Patterson is prepared at this time to waive his right to a preliminary hearing.
Okay. Mr. Patterson, do you understand that you are charged with felonies and you're entitled to a preliminary examination if you want one?
Oh, yes.
And you also may waive that. A preliminary examination is not a trial. Witnesses would be called by the State to testify against you, and you have the right to have your attorneys cross-examine them. You also have the right to present your own evidence. The purpose of a preliminary examination is to determine whether probable cause exists. Probable cause means facts together with reasonable inferences from those facts, which would lead a reasonable person to conclude that a felony has probably been committed and that you probably committed it. If the court finds there is probable cause to believe that you did commit a felony, you would be required to stand trial. If the court does not find probable cause, the charges would be dismissed or reduced, or the State may refile. Do you understand your right to a preliminary examination?
Yes, sir.
Do you want a preliminary examination?
No.
And do you understand the charges against you at this time?
Yes.
Have you had enough time to discuss the waiver of preliminary examination with your attorneys?
Yes.
Did anyone make any threats or promises to get you to waive this right to a preliminary examination?
No.
Mr. Glenn, have you and Mr. Jones haven't had enough time to discuss the issue of waiver of preliminary examination?
We have, Your Honor.
And are you satisfied that his waiver is knowingly, intelligently, and voluntarily given?
We are.
Okay. The court will find that Mr. Patterson's waiver of preliminary examination is knowingly, intelligently, and voluntarily given, and the court will bind him over for trial. I have found a date for arraignment. Is the State willing to or ready to file an information?
The State is ready, Your Honor. I have provided a copy of the information both to Mr. Glenn and Mr. Jones prior to the hearing. May I approach?
Yes. All right. I will accept the information. I will schedule arraignment for March 27th at 1 p.m. Does that work, Mr. Glenn?
That does. Thank you.
And does that work for the State?
Yes, Your Honor.
All right. Anything else I need to address at this time, Mr. Wright?
No, Your Honor.
And Mr. Glenn?
No, Your Honor.
All right. We're adjourned.